The Sixth Amendment of the United States Constitution, this will be part one, which reads as follows. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. A lot of real important things going on here. 1, the inalienable right to a speedy trial. 2, the inalienable right to a public trial. 3, the inalienable right to an impartial jury of one's peers. 4, the inalienable right to be informed of the pending charges that have been filed against you. 5, the inalienable right to confront and cross-examine any adverse witness or witnesses. 6, the inalienable right to compel favorable witnesses to testify at trial through the subpoena power of the judiciary. And 7, the inalienable right to assistance of counsel. The inalienable right to a speedy trial. In the United States, when a person is accused of a crime, that person has a right to a speedy public trial. Now, this doesn't mean that they're going to be rushed to trial and then rushed to judgment, but rather that a person cannot be made to wait in jail for long periods of time, like years, for example, while waiting for their trial. It would be a cruel punishment indeed for an innocent person to spend time in jail while waiting to prove their innocence. Remember, innocent until proven guilty? Now, that's the reason for bail, the Eighth Amendment, which we'll cover in a later video, so that the innocent is not needlessly punished. The inalienable right to a public trial. The trial must take place in the area where the crime was committed. The trial must be open to the public. There can be no secrecy whatsoever. The process must be fair and just and be open for all of us to see. This ensures that our government is always playing by the rules. The inalienable right to an impartial jury of one's peers. Unless the accused waives his or her right to a trial by jury, the trial will be judged by a jury and be judged by a jury of the accused's peers. Now, jurors are called from a pool of people called the jury pool from within the community. Usually the jury pool comes from the voter registration records. Now, the jury must be impartial, which means that the jurors cannot be biased or prejudiced against the accused. Now, to ensure that the members of the jury meet these requirements, there's a process called voir dire, which is French for to speak the truth, a process through which potential jurors are questioned by either the judge or the defendant or counsel to determine their suitability for jury service. You see, the trial must be fair, or as fair as possible. The inalienable right to be informed of the pending charges against you. You see, a person that's charged with a crime has a right to find out what the charges are and why they're being held in custody, in jail. The inalienable right to confront and cross-examine adverse witnesses. A person charged with a crime not only has the right to know what the crime is, he also has the right to confront the person or persons who are making the claim or the accusations against them. Now, this includes the right to confront your accusers at trial and to ask questions. Things like examine and cross-examination, anything there is that can be used to ascertain the truth. The inalienable right to compel favorable witnesses to testify at trial through the subpoena power of the judiciary. The accused has the right to compel anyone to testify on their behalf if they believe that the person's testimony will help them with the case. Now, although a witness can voluntarily appear to testify in court, Normally their appearance is done by subpoena, compelling the witness to appear or face contempt charges for failing to do so. Always subpoena your witnesses, even if it's your wife and or your best friend. People who promise to show up rarely do. Okay, this brings us to the inalienable right to the assistance of counsel. The assistance of counsel is an extremely important right. The term counsel has been watered down over the years by the courts to mean the right to be represented by an attorney. And of course, if you can't afford an attorney, the right to have the court provide one for you. The inalienable right to the assistance of counsel and the right to be represented by an attorney are not the same thing. In a criminal trial, a criminal defendant has the unqualified right to assistance of counsel of his choice, not the court's choice, not to choose from those who are members of the bar, but the assistance of counsel of the defendant's choice. A right that goes hand in hand with the right to plead and manage his own cause personally, utilizing the assistance of any person or persons that he would depend upon for his defense. The right to freely associate, assemble, or speak with the persons the defendant depend upon in assisting him in his defense, believe it or not, encompasses the entire protection of the Bill of Rights and cannot be suspended by any law or statute or by any court of the land, providing that those persons assisting the defendant do not hold themselves out to be attorneys or taking fees or other consideration in compensation or remuneration for their services. The right to the assistance of counsel encompasses a citizen's right to represent themselves and handle their own legal affairs, which includes, but not limited to, the right to conduct your own defense in your own way and in your own manner, providing that you obey all the rules of procedure and you don't disrupt the court's decorum, and the right to defend yourself with or without the assistance of counsel and or the representation of an attorney. See, I separated the two. Assistance of counsel or the representation of the attorney. There is a big difference. The courts won't tell you this, but there are. Now, quoting from a case called Ferretta versus California, which can be found in 422 U.S. 806, quote, "Either party has a natural right to plead his own cause. This right is consistent with safety. Therefore, it is retained. But the parties may not be able. Therefore, the civil right of pleading by proxy, that is, by counsel, is an appendage to the natural right of self-representation." The United States Supreme Court has ruled that the right to self-representation is a natural right. It's natural, something everybody has a right to do, and goes hand in hand with a person's right to the assistance of counsel. Now, as the Supreme Court has ruled, counsel is nothing more than an appendage, a tool used to assist in the natural right of self-representation, which includes, but is not limited to, any defense tool necessary to perfect a person's defense. And this applies in both state and federal courts. You see, all attorneys are counselors, but not all counselors are attorneys. Okay, bear with me a minute here. These two rights, the right to self-representation and the assistance of counsel, have been widely abused by the courts, and they have been abused by their brothers of the bar, the American Bar Association. The American Bar Association is nothing more than a closed-shop corporate monopoly that has hijacked our judicial system, forcing people to hire bar members to represent them in court, and for exorbitant fees, I may add, or face the chilling prospect of standing alone before the awesome prosecuting power of the state with no assistance at all. Today, judges wrongfully equate the term counsel with a licensed attorney, and they do so to protect the financial interest of their brothers of the bar, when in fact the term Assistance of Counsel, as written in the Sixth Amendment, means much more than being represented by a licensed attorney. Assistance of counsel also means lay counsel, somebody who is not a licensed attorney. Persons that are learned in the law and courtroom procedure that can assist the defendant at trial at the defendant's pleasure, providing that lay counsel is not holding themselves out as a licensed attorney or receiving any reward or fee for their pains. Quote, "The first lawyers were personal friends of the litigant brought into court by him so that he might take counsel with them before pleading." And that comes from a case called Ferretta versus California, 422 U.S. 806. The Massachusetts Body of Liberties in 1641, in Article 26, provided, now listen to this wording, "Every man that findeth himself unfit to plead his own cause in any court shall have liberty to employ any man against whom the court doth not accept to help him, provided he give him no fee or reward for his pains." And once again, that's out of Ferretta versus California, 422 U.S. 806. And, quote, "that in all courts all persons of all persuasions may freely appear in their own way and according to their own manner, and there personally plead their own cause themselves, or if unable, by their friends." Not Ferretta versus California, 422 806. When representing oneself, the defendant remains the attorney of record and maintains total control of their defense at all times. And as I stated earlier, counsel is nothing more than an appendage to the defendant's right to self-representation. It's like the assistance of a researcher, or the assistance of an investigator, or the assistance of a paralegal, or the assistance of an expert witness, or the assistance of a secretary, or any other needed person to assist the accused in the preparation of any document and or any needed assistance at trial. On the other hand, the licensed attorney represents the defendant in his stead. And through the power of attorney, the attorney becomes the defendant and has complete control over every aspect of the case, and does so for a fee. Lay counsel is used to assist, not represent the defendant, and usually is a knowledgeable, trusted friend or friends whose assistance is paramount to the successful outcome at trial. Now, I'm going to cover the right to self-representation and the assistance of counsel in a video following this one. I will show you how I present this argument to the court and how it is reversible error for the court to deny me the right to self-representation and my counsel of choice. So stay tuned. I am the Ghetto Man. Thank you for watching. If you're politically correct, then you're legally wrong. And if you're not part of the solution, then you are the problem. Please subscribe to my BitChute channel and please share.